Thank you. And Mr. Hawkins, I know you're trying to catch a plane. Anything you need to respond to? I had some questions for you, and especially with regard to how Texas is using Section 2 of the Voting Rights Act. But anything based on what you heard you want to add before you have to go?
Thank you, Representative. I think it's important to underscore that Texas has a duty under state and federal law to ensure that its voting rolls are accurate, as does every other state. And in fact, Texas has a compelling interest in ensuring that ineligible voters do not vote. Now, why is that so? It's because anytime somebody votes unlawfully, that suppresses the vote of a lawful voter. And that's why we're seeing not just Texas, but many other states, including just this week, California, auditing voter rolls to ensure that only registered voters are, or that only eligible voters are registered to vote. That is the purpose of auditing voter rolls, to ensure that the right to vote is protected, because if somebody who is ineligible to vote votes, that suppresses the vote of a lawful citizen.
Appreciate your efforts so much. And I would like to indicate for the record, and I won't have any further questions, Mr. Hawkins. I'm told that you're trying to get away, but with regard to the need for this hearing and all, I think it's important to know the facts on the reauthorization of this. I was fairly new here in Congress, but it seemed very clear to me that since Section 4 had not been changed for about 40 years, it was still penalizing states for sins, wrongs, decades before by fathers and grandfathers, so to speak. And so I know Chairman Sensenbrenner was pushing hard. He didn't want changes. He was not open to my suggestions, but we had looked at a map of areas where there was a very definite problem, a disparity in the numbers based on racial voting, and there were some problems around the country that were not included in the states that had to get Section 5 clearance. And I had an amendment that would require any state that had a significant disparity in racial voting, they had to fall under Section 5. And let's update that. Section 4, let's get a new standard in there. And Chairman Sensenbrenner said, absolutely not, we're not changing it. And as I recall, there was a district in Wisconsin that had a significant disparity problem that might have fallen under Section 5. And Mr. Conyers was much more open to the idea of having an amendment that would require any district, any state in the country with a racial disparity problem would have brought them under Section 5. And I'd said most recently, the second time I talked to him, he was open to it. He said, you know, Louie, I've been talking to some of our experts, and they say, yeah, it's a risk. It might get struck down, but so why don't we just go ahead and wait and see what happens? And I said, I just talked to the previous dean of New York University Law School, and he said he sees a substantial chance that it will be struck down by the Supreme Court when it gets there. But the bill was done. They would not allow my amendment to be passed, and therefore it would continue to punish only those who had engaged in wrongdoing decades before, instead of bringing it current to make district states that were failing to have fairness racially have to answer under Section 5. And just as I predicted, just as others predicted, it got struck down, and we're still here without a modification that could have been done back in that reauthorization. So anyway, I'm hoping that we will work things out. I'm proud of the way Texas has been using Section 2 litigation to get this straight, or get problems straightened out even without changes to Section 4. And appreciate the chance to air these matters and yield back.